Our government is focused on delivering the clear mandate that Albertans gave us to stand up for this province, protect our freedoms, and chart our own path forward. That's why we are taking the next step to defend Alberta's constitutional rights through Bill 1, the International Agreements Act. Ottawa can sign international agreements with other countries, that's their right, but this legislation makes it clear that those agreements will only become enforceable in Alberta if implemented under provincial legislation. Work with us, and we'll get things done.
Hello, everyone, and welcome back. Now, from what you've seen recently in my videos, we take federal bills going through Parliament in Ottawa, we break them down, we criticize them, and go through what's wrong with them. Today, we're doing something a little bit different because today, we're actually going to go through a bill that is positive for those of us here in Alberta. Because finally, our Premier, although conservative like me, I don't always give her credit for that much. But for once, she's decided to actually stand up for Alberta, to stand up against Ottawa, and introduce Bill 1. So we are going to go through it as it has not yet passed in Alberta legislature. This will probably be the only provincial bill we do, or maybe one of very few, as we will be going back to the federal bills that go through Parliament. But I decided today we're going to do something different. And we're going to go through a bill that's actually bringing a little bit more positivity and a little bit more independence and sovereignty to Alberta. Let's go. All right, so we're going to start with the preamble. As you see up on the screen here, there is the table of contents. We're going to get through all of that. However, we'll start with the preamble, okay? So the preamble says, whereas Albertans possess a unique culture and shared identity within Canada. I disagree, but moving on. Whereas it is the role of the Legislative Assembly of Alberta and the Government of Alberta to preserve and promote this unique culture and shared identity. Whereas the Constitution Act of 1867, the Constitution Act 1930, and the Constitution Act 1982 are foundational documents that establish the rights and freedoms of Albertans and the relationship between the provincial and federal orders of government, including the division of legislative powers between them. Whereas the province of Alberta is granted rights and powers under the Constitution Act 1867, the Constitution Act 1930, and the Constitution Act 1982, and is not subordinate to the Government of Canada. Whereas actions taken by the Parliament of Canada and the Government of Canada have infringed on the sovereign provincial rights and powers with increasing frequency and have unfairly prejudiced Albertans. Whereas actions taken by the Parliament of Canada and the Government of Canada have infringed on the rights and freedoms of Albertans enshrined in the Canadian Charter of Rights and Freedoms in an unjustified and unconstitutional manner. Whereas the people of Alberta expect the Parliament of Canada and the Government of Canada to respect the Constitution Act 1867, the Constitution Act 1930, and the Constitution Act 1982 as the governing documents of the relationship between Canada and Alberta, and to abide by the division of powers and other provisions set out in those documents. Whereas the people of Alberta expect the Parliament of Canada and the Government of Canada to respect the rights and freedoms of Albertans enshrined in the Canadian Charter of Rights and Freedoms. And whereas it is necessary and appropriate for the Legislative Assembly of Alberta to set out measures that the Lieutenant Governor in Council should consider taking in respect of actions of the Parliament of Canada and the Government of Canada that are unconstitutional or harmful to Albertans, and for members of the Legislative Assembly of Alberta to have a free vote on such measures according to their individual judgment. Therefore, His Majesty, by and with the advice and consent of the Legislative Assembly of Alberta, enacts as follows. Nothing in this act is to be construed as authorizing any order that would be contrary to the Constitution of Canada, authorizing any directive to a person other than a provincial entity that would compel the person to act contrary to or otherwise in violation of any federal law or contrary to or otherwise in violation of any federal law or abrogating or derogating from any existing Aboriginal and treaty rights of the Aboriginal peoples of Canada that are recognized and affirmed by Section 35 of the Constitution Act 1982. Resolutions, if on a motion of a member of Executive Council, the Legislative Assembly approves a resolution that states that the resolution is made in accordance with this Act, states that, in the opinion of the Legislative Assembly, a federal initiative is unconstitutional on the basis that it intrudes into an area of provincial legislative jurisdiction under the Constitution of Canada, or violates the rights and freedoms of one or more Albertans under the Canadian Charter of Rights and Freedoms, or causes or is anticipated to cause harm to Albertans, or sets out the nature of the harm if the resolution states that in the opinion of the Legislative Assembly, initiative or is anticipated to cause harm to Albertans, identifies a measure or measures that the Lieutenant Governor and Council should consider taking in respect of the federal initiative. The Lieutenant Governor and Council may take the actions described in Section 4. Now we'll go over Section 4 as we just kind of notion to it. Powers of the Lieutenant Governor and Council. So this elaborates more on the previous section we just went through. So, Section 4, Powers of the Lieutenant Governor and Council. If the Legislative Assembly approves a resolution described in Section 3, the Lieutenant Governor and Council, to the extent that it is necessary or advisable in order to carry out a measure that is identified in the resolution, may, by order, if the Lieutenant Governor and Council is satisfied that doing so is in the public interest, direct a minister responsible for an enactment as designated under Section 16 of the Government Organization Act to, by order, suspend or modify the application or operation of all or part of an enactment, subject to the terms and conditions that the Lieutenant Governor and Council may prescribe or specify or set out provisions that apply in addition to or instead of any provision of an enactment, subject to the approval of the Lieutenant Governor in Council. Direct a minister to exercise a power, duty, or function of the minister, including by making a regulation under an enactment for which the minister is responsible, or issue directives to a provincial entity and its members, officers, and agents, and the Crown and its ministers and agents in respect of the federal initiative. A directive issued in accordance with subsection 1c may be general or particular in its application, where there is conflict or inconsistency between an order or an order that is directed to be made under subsection 1 and a provision of an enactment to which the order relates. The order prevails to the extent of the conflict or inconsistency. Nothing in this act abrogates any authority or power vested in the Legislative Assembly or Lieutenant Governor and Council by any other enactment or by operation of law, including any authority or power of the Lieutenant Governor and Council to take action with respect to the federal initiative. All right, guys, bear with me here. We're getting through this. It's long. There's a lot to go through. We're heading on to Section 5 of this bill, the authority and orders C's. Okay, there's still a bit to go. For those of you still watching, please bear with me. This is a very, very important bill that could impact the future of Alberta and be a significant piece of both Alberta history, Canadian history, and potentially American history. So this has a lot riding on it. Here we go. Section 5, subsection 1, subject to subsection 2, the Lieutenant Governor and Council ceases to have an authority to make an order under Section 4, subsection 1, and any order issued by the Lieutenant Governor and Council or a minister under Section 4, subsection 1, expires and ceases to have any force or effect on the earliest of A, the date on which the Legislative Assembly rescinds the resolution referred to in Section 4, subsection 1, or B, 2 years after the date on which the resolution referred to in Section 4, subsection 1 was approved by the Legislative Assembly. Subsection 2 here, the Lieutenant Governor and Council may extend an order issued under Section 4, subsection 1 for an additional 2 years from the date on which the original order was set to expire. Subsection 3, an extension of an order by the Lieutenant Governor and Council under subsection 2 may be made only once. Effect of directives. This is section 6. A provincial entity and its members, officers, and agents, and the Crown and its ministers and agents must comply with any directive issued by the Lieutenant Governor and Council under this Act. A directive issued under this Act must be published in the Alberta Gazette within 30 days from the date the order is made by the Lieutenant Governor and Council under Section 4, subsection 1. Section 7. This Act is binding on the Crown. That was an easy one part. Section 8. No cause of action. No cause of action lies against, and no action or proceeding may be commenced against the Crown or its ministers, agents, appointees, or employees, or against the Legislative Assembly, the Speaker of the Legislative Assembly, an office of the Legislature, or any agents, appointees, or employees of the Legislative Assembly, or an office of the Legislature, in respect of any act or thing done or omitted to be done under or in relation to this Act, or a resolution or order under this Act, including, without limitation, any failure to do something when that person has discretionary authority to do something but does not do it, or any other person or entity in respect of any act or thing done or omitted to be done in good faith under a directive issued under this Act, including, without limitation, any failure to do something when that person has discretionary authority to do something but does not do it. Okay, we're on the final 2 sections, guys, here. I'm glad you're still watching and bear with me here. Section 9 is judicial review. So Section 9, subsection 1. An originating application for judicial review in relation to a decision or act of a person or a body under this Act must be filed and served within 30 days after the date of the decision or act. Subsection 2. And an application for judicial review to set aside a decision or act of a person or body under this Act. The standard of review to be applied by the court is that of patent unreasonableness. Subsection 3. Nothing in this section is to be construed as making a decision or act of the Legislative Assembly subject to judicial review. Section 10. Regulations. The Lieutenant Governor in Council may make regulations. A. Prescribing provincial entities for the purpose of Section 1, subsection E. B. Defining any term or phrase used but not defined in this Act. Okay, so now we've read the bill in full. We've gone through every part of it. We've determined the boundary of it. We've determined what it does, what the act of the bill is meant for. So, now, some of you might be wondering, while you may not understand all the terminology, which is fine, you may be wondering, what is the significance of this bill? Well, as we've seen in Canada in recent years, there has been a lot of overreach by the federal government in Ottawa. And even outside of Alberta, some of you may be seeing that there is a movement for Alberta to become independent from Canada, that there potentially will be a referendum in 2026 that will be voted on by Albertans on whether or not we remain a province in Canada or whether we become an independent country, which eventually could be leading to becoming the 51st state of the Union, part of the United States. So this bill is a clear directive to Ottawa, to the government of Canada, to quit overstepping, to stop the overreach, to stop thinking they have complete control over Alberta. And actually, it kind of sets a precedent for the rest of Canada as well, that Ottawa and the entire federal government needs to back off and realize that each province has the ability to make decisions for themselves. I personally like this bill, aside from some of the wording of it and phrasing of it, because it allows Alberta to have a clear voice. It allows Alberta to stand up for itself. Saskatchewan should have the same thing. They're a very close partner to us. However, this is a great step forward. This is Premier Danielle Smith finally sending a message to the Prime Minister of Canada and to all of his minions in the Liberal Party that they need to stop, and that Alberta should have the freedom to do what they want. And it also prevents certain bills currently going through Parliament in Ottawa right now from actually being enforced here in Alberta. A couple of them I already have videos up. I will put little tags up in the corner here that you'll see for some of those videos. If you haven't seen them yet, I've got them for C8, C2, C9. C2 has already been dropped. There's a couple more I will be getting to. So Alberta is basically putting its foot down here and declaring that some of Ottawa's overstepping and overreaching regulations and laws they're trying to pass will not be enforced here. They will not hold any principle here in Alberta. All right, guys, that's going to be it for this video. Thank you guys so much for watching. I understand this was another long one. Thank you for bearing with me. If you haven't yet, please subscribe. If you'd like to see more, if you'd like to be getting early access to my videos, make sure you get a channel membership. It really helps me continue to do these videos. You'll get to see videos like these before everyone else, and I'll see you in the next video.